Well, it was a correct verdict. The judge found him not guilty of drunk driving, basically, of the DUI, the impaired over 80, and Rick's very happy. It takes a lot of pressure off his shoulder. He was very, very upset through this whole ordeal, and it's been going on since July 2009.
What do you think it was that changed things for you? Because, as you say, it didn't look like it was going all that well.
Well, there's constitutional and chart arguments that are complicated, and the judge is very experienced, but the big thing is the video. I mean, 20 years ago, they didn't have an audio video of somebody at the station, and the audio video, it's like painting a picture as 1,000 words, and he wasn't drunk, he was tired, and it was on a video, was contrary to what the arresting officer and the qualified breathalyzer technician had to say, and thank God we had the video, because that saved the day as the evidence acquitted the captain of the Maple Leafs.
Can you talk to the over 80 charge, how the machine said he had twice as much legal limit, but the judge still found him not guilty?
It has to do with the case law, the Supreme Court of Canada, that it's not like you prefer one person's evidence. He testified, Mr. Derlago, the former Maple Leaf, and Trevor Whiffen, the sports agent, very prominent lawyer, all said that, basically he wasn't impaired, and on the machine is not always correct, but the point is that you look at all the evidence and you decide what you're going to find on, and she found in favor that the honest people were Rick Vaive and the sports agent and Derlago, and not that anybody was being untruthful. The police have a tough job to do. They have to cross their T's and dot their I's, but here, beyond a reasonable doubt, he was found to be innocent of this DUI type offense.
So, Calvin, if it had been taken within the first 2 hours, there was something about a 2-hour limit.
Right, because that's a change in the law. The Supreme Court of Canada, you have to get the first breath in within 2 hours of driving.
And so if they hadn't have got it in with the first 2 hours of driving, and he had been shown to have twice the legal limit in his blood alcohol, would you think he'd be having the same verdict today?
I think so. There's a lot of factors here, and also strategies. I've been doing this 25 years, and I was a senior prosecutor. I may have approached the case differently if I knew other things. There's other defenses we had that I decided not to play, and so we had a number of defenses here, but the one that won the day was basically he was not impaired, and the evidence of him having the 6th beer was believed by this very experienced trial judge.
So you did still have right after beers, though, and got in the car and drove, so you've done these things before. Did he get lucky here? Did you just come up with, we heard the testimony, but...
Yeah, not at all. It was a time frame, and he had been drinking over a number of hours and hours. You hear the thing in bars about pacing yourself, and basically what the evidence was is that he blew .15, which is like basically one-fifth of what the legal limit is on the evidence. He was a tired fellow that was playing golf with a bunch of ex-NHL hockey players. It was a hot day, and he's wearing flip-flops, and it is what it is. The judge heard everything, and the police put their best foot forward, and he was acquitted because he should have been.
You spoke to Mr. Vaive right after the verdict was delivered. His wife was emotional. What did he say to you?
Well, he just said, he's happy, and it's a lot of pressure off him. It was killing him. He's never been in trouble before, and he's used to being on the spotlight of being the captain of the Maple Leafs, doing charity, doing a lot of police work. He's just a lovable, nice fellow, and it was very, very tough on him. And he's very, very happy today. This is probably the best day that he's had in years.
So did the ruling mean that 2 hours later the alcohol effects got worse for him than when he was in the truck?
Well, technically the way that this works is that there's absorption and elimination of alcohol, and there's toxicologists. We could have called a toxicologist, but I was able to get what I wanted from the prosecution toxicologist. So these are doctorates that are experts, and basically as time goes by, you plateau and then you start going down. And so basically, according to that machine, he would have been at a level that would far exceeded 80, but from what he said he could drink, he was under 80, basically at the time at the time of the driving is what's the operative. See, the reason they have a presumption in criminal code is because you're not going to have that big machine, like something like the Flintstones at the side of the road, and put it to somebody. You have to say there's a presumption that we go back 2 hours, and that's what your alcohol in your blood was at that time, because obviously you'd have to walk around with this big suitcase with you, and maybe technology might make the machine smaller, like it's had with computers.
So it's basically saying then that when he was driving, he had 5 or 6 beers over 5 or 6 hours, and he wasn't drunk. But when he stopped, they all added up.
And I would, you have to look. It's 4%. It's light beer, Coors Light. I mean, it wasn't like he was doing shots or bar shots or some waiter free pouring wine. So you have to look at all of these. We specialize in this area of DUI, impaired over 80s, and it's very technical. But we had a very fair judge that knows the law. And to some lay people, it looks a little confusing in there. But basically, to make it simplified, he was tired. He was playing hockey with his friends. He was playing cards. He did have something to drink, but he wasn't drunk.
He's had to reveal a lot of very personal information. What kind of toll has that taken on him?
Well, it's not fun. I mean, when you're going up there and telling the truth, it's warts and all, right? It's the good and the bad and the ugly. He has to talk about things. And, one thing you have to know is in terms of let's wait till all the evidence gets out, and then let's see what the trier of fact does, or the jury does, or the judge. I mean, it looked bad, and it looked, some of the facts that were coming out, but even the part about the Gatorade, I mean, completely explained by a doctor, a very seasoned urologist. So, when you look at somebody that looks like they're stumbling around, and then you find out they're wearing Crocs, and it's a hot day, you got a big truck, and you hit a curb. I mean, that's indicative of non-impairment too. That's consistent with sobriety for people that are just trying to go about their day.